Hello, beautiful people. Welcome back. Elements, standards, and tests. As time has been going on, either in the middle of some sentence, you would hear me speak of elements, standards, tests. In the past, we went over the elements, the standard, and the test of malicious prosecution. As of recent, we've also went over the elements and the standard and the test of that thing called probable cause and how it's linked to the standard and the test of reasonable suspicion. We've also went over the elements, standards, and tests of cruel and unusual punishment. See, these are very vital spots of what people call their rights that you must know. But the question you ought to ask beyond just the things we've went over, because sometimes you will see it, it will make sense, okay? So these are the qualifying factors. These are the explanation of what it is. But in truth, you still need to know the root of what this thing called elements, standards, and tests really means. Just as much as some older generation would look at a younger generation and say, look at them, they're not responsible, they're wimps. Back in my days, we used to do this and that. When in truth, that's just an excuse, because you, the older generation, are the one that the younger ones are supposed to be learning from. You, the older generations, you are the same one who gave birth to those younger generations. It might not be you directly, but that son, that daughter's parents, you're of the same generation. So that means something has went wrong in your generation for the newer generation to be fucked up. Just as much as the poor people always say, tax the rich, something is wrong with the rich. When in truth, the poor ones are the ones voluntarily enslaving themselves when ample opportunity to not be a slave exists. When ample opportunity to network in the age of technology exists. When ample opportunity to earn financial education so that you could truly begin to not enslave yourself for this money. If you work so hard for money every day, why not just learn about this thing that you work so hard for so that you don't keep enslaving yourself on its behalf under an excuse that you're hardworking, you're diligent, you're taking this beauty and prestige and being poor and working for someone else. Just like people who come into the intent of wanting to free themselves by dealing with the language of the law one way or the other. They loosely read a verbiage. They read it and interpret it the way they want it to, because it makes them comfortable at that moment without comprehending the intricacies. And when something goes wrong, they start to point fingers. They're fraud, they're bad, they're this. You know what all those three examples have in common? The older generation looking down on the younger ones without realizing they themselves are the cause. The ones creating all the screwed up legislature that's screwing everybody up in today's world, the ones holding the mantle of power that's screwing society up, are not the younger generations. The ones in the legislative department, judicial department, executive department, they're the older generations, and they're conditioning the young ones on their end, in their immediate environment, to perpetuate the same thing. When you go to a destitute neighborhood that's screwed up and you look at the attributes of the older ones, as much as they might want to play all holy and perfect, you realize they're fucked up too. As much as you will go to a poor neighborhood or a poor family and you look at the younger ones having a poor mindset, a poor lifestyle attributes, you will see the same thing in the older ones also. It's okay to have less, be content with less. The lies, instead of telling them aspire to be the best as you can without taking advantage of others. Educate yourself to know how the world works and be the best at everything you do, and make sure that you don't strive to suffer and then try to take virtue in it. You wonder why the younger generations live today like there's no tomorrow? Because the older generations don't have parenting skills. There are exceptions, but the majority of them don't. They just like to claim being old. They don't comprehend that the amount of time you spend on this earth is not equivalent to your potential or your level of intelligence. Most people are walking around here with low, slow, draggy, dead cells, and they're taking pride in that. When in truth, there's no capacity to really change the world functionally beyond what you think you've done on this earth. Just spending time, just wasting space, just breathing up air. Same thing applies with people who learn things of this nature. They're wasting time. They're creating res judicata's against other people, just wasting space, just breathing air, filing a bunch of papers after papers after papers, creating a pathway for others to be screwed up because of their naivety, their lack of willingness to take education to actually serious, beyond merely reading words to make them feel good. They just want to point a finger, someone is bad, you did that, you didn't do this, you didn't do that. But you yourself don't understand or comprehend the language and the substance, the subtle substance behind what you say your rights are. One thing all those three groups of people, the old generations scorning the young, or the young scorning the old generations, the poor scorning the rich, or the rich scorning the poor, or those who say they have rights scorning the people they say are tortfeasors, or tortfeasors scorning the ones who say they have rights but don't know their rights. One thing all those three people have in common is they just constantly point fingers without comprehending the substance and the root of it. And even deeper is self-responsibility. There are always exceptions in all those categories, always, because that exception is the perfective mechanism that would always exist in nature to balance the scale when it's tipped a little bit too far. But for most parts, it is the norm. Everyone always wants to point finger. You are doing this bad, you are doing that bad. When in truth, just comprehend what you're doing, and you will have no need to look at others. In fact, where there will be a need to point at someone about doing something bad, you will see an opportunity there. You're saying you know your rights, but if you don't know the elements, if you don't know the standard, and if you don't know the test, the element is this thing called cause of action. Whenever an acting judge reads your paper, screw your feelings, screw those buzzwords you're using, screw those dictionary definitions, screw all those reference to the law that you're citing. Nobody cares about that. What they're looking for is the substance, which is the element of it, the core of it, which they call cause of action. Have they qualified for this thing that you're saying they violated? How do you determine if they qualify for this thing they violated? The elements. Now that we've determined they've qualified for it, or before we determine that they qualified for it, because there's a little bit of gray area, we're going to put it to test based on the totality of your circumstance, not the other man's circumstance that gave rise to a res judicata that you're citing now, but your specific instant. We're going to look at your mannerism, your temper. We're going to weigh the countervailing balance of government interest and public peace. We're going to weigh your mental capacity based on how you interacted with them, whether it's recorded audio and video or on piece of paper. All those subtleties will be looked at to test whether you qualify to state a claim upon which relief can be granted, or whether they qualify as a party who has violated a supposition of crime that you're bringing as a cause of action. Cause of action being the elements in it. So now you see the test and the elements are tied together. And then there's this thing called the standard. Meaning no matter what you do, no matter how you do it, there's a parliamentary rules of procedure of how we're going to accept it, how it's going to be done. A perfect example of service of process. There's a standard to service of process. You have to get the clerk's seal or the administrative seal. You have to get a neutral third party to serve it to someone else. That's a standard. Simple. It's like an affidavit. There's a standard to an affidavit. It has to be attested by someone who can act as a witness, either in an official capacity, which is the best, or if you don't have access to it and you can show a reasonable good cause that you don't have access to, that man or woman who has an official seal that's self-authenticating can get other people to sign it. You have to swear to the truthfulness as a standard of what an affidavit is. And you have to have first-hand knowledge and experience of it. It can't be a speculative feel-good trash that you heard somewhere that you're regurgitating on a piece of paper, like unrebutted affidavit is truth and sovereign of commerce. That's not even a true maxim of law of equity. It's not. It's just some trash some people made up. So, and then it goes on and on. Standards, elements, tests. If you don't understand these three triangles, you can and will never be able to state a claim upon which relief can be granted. Elements of a case. Elements is one point and one end of those triangles. Like a triangle, if you remove one side, the other two will fall or the other two will wobble. They need each other and they're codependent to stand upright. Whether you're looking at it from a 2D perspective or from a 3D perspective. Elements of a case. Elements of a case are component parts, like you would have an automobile, vehicle, a car, whatever you want to call it. And then you have different parts working together to make that one thing that you see as totality that's called a vehicle. A machine, that's what the legal system is. It is a machine. The legal system being the quote process that everyone is going after. The word process and legal, same thing. And legal, or the word process, is merely the operation of law. Law is the basics, the most basics and the basics that everything shoots out of. Like the Big Bang, where all these other supposedly universes, planets, galaxies come out of. Well, law is that Big Bang that every other type of legality comes out of. And they're telling you that elements is the component part of a legal claim. Meaning those things that shot out of that Big Bang, out of law, it now has intricacies to it. It now has subtleties to it that a lot of people overlook. They just read something on a piece of paper, they interpret it as what they want, and they try to slap someone in the face with it and think someone owes them something, or that someone is less than one thing or the other, that someone has violated something. The real world does not work that way. The reason why 9 out of 10 people who study things of this nature have failed on their face, and they're allowing all these tortfeasors that they hate so much to keep kicking their ass just because they're looking for some instant gratification of, oh, I sent that, look at that, I did this. But how did it end? How did it end? Don't show us the middle part or the beginning part of what you did. I just filed a suit. Yeah, okay, how did it end? Did you win it? Did you gain some type of asset that will be making you more monies in the future from that? No? Okay, well, you're not doing anything. Elements of a case are the component parts of a legal claim or cause of action that a plaintiff, meaning you, the claimant, must prove to win a lawsuit. Meaning a suit at law. You're trying to go back to the Big Bang, but you need to comprehend the subtleties of it. Most people don't comprehend the subtleties of this thing called law or its operation called legal matters. People fill their papers with conjectures. People fill their posts and things they do with conjectures and how they feel or what they think it's supposed to be. Get out of your subjective state of mind and deal with things objectively. Deal with the great secret is this, of how you really construct any good piece of paper, whether it's a lawsuit or not. Just focus in the elements, tests, and standards, and that should be the circle of language that everything you're writing should revolve around. If you allow that to be the scope of what your paper is dealing with, then you're doing something. Again, elements of a case are the component part of a legal claim or cause of action that a plaintiff must prove to win a lawsuit. A cause of action is what allows you to state a claim upon which relief can be granted. If you don't have one, you haven't stated a claim. Cause of action is a set of predefined factual elements that allow for a legal remedy. In other words, again, for you to state a claim upon which relief can be granted. The factual elements needed, meaning it's a necessity. The factual elements needed for a specific cause of action, meaning there's cause of action And what makes that cause of action as its building blocks are elements, factual elements. And this is not just affidavit of fact or whatever you think an affidavit is. Factual elements needed for a specific cause of action can come from constitution, meaning the law, the Big Bang, the source. Statute, meaning if you're seeking a statutory remedy. Most of these things people do with all these administrative agencies are limited by statute. Judicial precedent, the quote, judge-made laws, common law that everyone hangs on its balls. Or administrative regulations, which is where most of these private entities that you're interfacing with on a piece of paper function. Because they have the rights and obligation of contract. They're not going to tell you that. And now you're trying to go into public court talking about a whole nother thing whereby each of these aspects has their own elements. For instance, the Constitution, the Fourth Amendment, Eighth Amendment, we went over some of those elements. Each legal claims consist of elements, quote, meaning whatever claim you're bringing in, there are elements to it. Those elements are the building blocks and the core, the substance of what you're doing. Each legal claim you're doing a court of satisfaction, there are elements to that. There are res judicata that list the elements. Some synonymous with the verbiage of 3-311, some not so much. You want to claim the Fourth Amendment right to not be searched and seized, or your right to be secured in your person's papers in effect, there are elements to that. You want to claim free speech, there are elements to that. Within those elements, they're qualified by tests and standards. Oftentimes, the standard is where you will see the exceptions, where it will tell you, yes, you have the First Amendment right to speech, whereby you can flick someone off or use profanities. Those are preserved First Amendment rights. But exceptions are your intent. If you're inviting someone to something called the verbiage of the judge-made law that they use is fisticuffs, meaning you're inviting someone to fight. Now you're using the First Amendment right to create public disturbance. And your intent is to harm someone else. At that point, that verbiage or your writing or imagery or symbolism cease to be protected by the First Amendment. That's the standard. Those are standard tests and elements, and they all go hand in hand. That is what it means here when it says each legal claim consists of, quote, elements that the plaintiff must prove in order to prevail. We literally just gave an example of any given circumstance with freedom of speech. Of course, there are more diverse examples, but that's just one. If you're not talking about those, the elements standing in the test in your piece of paper, and you're saying you're suing someone, they're gonna throw your paper away. At best, they're just gonna put it to the side, go deal with some other important matters, and come back and just dismiss it. If they don't want to give themselves the headache, they're just gonna shut you down right from the start and deal with some technicalities. That's unrelated, because if you don't know these basics, then surely you don't know the technicalities, and you don't know how to discern whether it's related or not. It makes me cringe when I read some case laws about certain things where it's like, man, these people shouldn't have been able to do this, but then I realize, oh, the one who brought this claim is the one that actually didn't get it. Because had he or she really understood or comprehend this thing, and they wouldn't have been able to do this. Basics like rebutting a judge's order. People don't know to do that. It's like people are almost afraid to rebut a judge's order. Like, what are you doing? Each legal claims consist of elements that the plaintiff must prove in order to prevail. You want to sue people for third-party debt collector? You want to sue people for hard inquiry? There are threshold elements to those. And 3 separate elements. Each claim, whatever you say your rights are, there are elements to it as to why they exist. A lot of people don't know that. They just say, I have the right to do this, right to do that. You ask them, okay, what is the element to it? They don't know. All right, at least what is a test to it to qualify? No. What is the standard, which might serve as an exception that might limit you from even bringing the test of elements? People don't know. People do not know. People want to discharge. You ask them, what is the element you're doing or using this specific type of discharge? They don't know. And yet they wonder why the tortfeasors get stronger and stronger every day. And it seems like they're getting more fraudulent and more fraudulent every day. It's because of lack of education on the part of the people who are saying that they're being treated in a torturous manner. The plaintiff can prevail in a civil case only if each element of the legal claim is proved by a preponderance of the evidence. We went over this in the past with a rule of evidence. They shoot you clues everywhere. They have rules specific for evidence. And when you look at the different types of law, they categorize evidence as a type of law of its own, evidentiary law. Should this not begin to tell you, once you know what the elements, test, the standard of your claim are, now look into the rules of evidence and the other standards of how to introduce you to make yourself authenticated or not, to then attach to your element, test, the standard. That's, once you got that together, I mean, it's really that simple. It is actually that simple. The only thing it will cost now is just the time to gather it and to just put it together in a strategic way, whereby it will be clear to the fact finder, but to the other party, it will be vague to them. You do want to do that as part of strategic planning. You want to make it so clear, yet not so clear to them, because they, on the other hand, use emotions also. Because these attorneys are convinced that the everyday men are stupid. They really are. They are very convinced, very satisfied, and very comfortable. And they rely on the fact that the everyday man knows nothing. And when they're about to get their ass kicked, and the rest of the judicata reflects that they were the attorney on that case, they start scrambling and try to settle with you. And even then, you can just see and tell that their ego is still in the way. Those who's been there know. But how can one ever get to that point if they don't comprehend these most basic principles? Instead, they feed you the belligerence that you want to hear. Martial law this, martial law that. Okay, before someone starts feeding you about martial law, first learn about the standards and elements of that thing that you're saying they're creating martial law against. Then wage and compare it to see whether it truly applies or not. Because remember, all law is specific. When they say martial law, if you yourself know all laws are specific and they're telling you martial law, did you not stop for a moment and go, okay, martial law is a type of law of its own. So that means it's only applicable to certain things. So now let me look at the Constitution to see what Constitution applies to. If this man or woman is saying martial law is suspended in the Constitution, then wage the comparison. But you cannot wage the comparison if you don't know what the Constitution applies to and the legality of how it's enforced and the elements, standard, and test of it. If you don't know the basics, anyone will pull the wool over your eyes and tell you something and you are wrong with it. And you will be convinced throughout your whole entire journey that that's what it is. And you will view everything and everyone else with that impartial, cracked, blurry, sideways, tilted lens. Yet, one will be convinced that, no, that's the proper perspective. For example, here are the elements of negligence claim. Look at this. A lot of people claiming negligence, willful negligence, so-and-so. They're giving you an example of its elements. The existence of a legal duty that the defendant owed to the plaintiff. When it comes to municipal police, the question you ought to ask yourself is, do they owe legal duty to protect you? Remember, they're working for the purpose of public safety now, right? But then there also simultaneously exists private interests of closed corporations, which are the departments within these municipalities. But then you, on the third hand, are also saying you're a private man, right? The question you ought to first ask yourself is, do they have a legal duty to do anything to you as a private man? If so, is the public safety doctrine or their attachment to a private corporation through the municipality an attribute to it? Oh, but wait, they swore an oath to the Constitution. Okay, good. So now you're looking at the Constitution. So now what right are you invoking within that Constitution that they swore an oath to? And if so, do you know the elements specific to those rights? If you do, then there will be an existence of a legal duty that the defendant owed to you if you're coming in as a plaintiff. A second example of an element of negligence is this: the defendant's breach of that duty, which is the first one. So where's the preponderance of evidence that they acted contrary to their job description, which in truth is their oath to the Constitution? The plaintiff's sufferance of an injury. So how do you prove that you were damaged? Proof that the defendant breach caused the injury. How do you now link that damage that you've proven to their duty that they didn't do? How do you now link all that together? When a plaintiff brings a civil lawsuit against a defendant, they file a court document called, quote, complaint, that identifies the causes of action and alleges the specific acts of the defendant that violated the law. You know the reason why they ever so often uses this term, alleges? Because they know 9 out of 10 people who will bring claims just makes allegations. Remember here, these are now 2 different spectrums that they're looking at things from. They just told you exactly what you need to do here to win a case, which is you need the components, which is the elements, in order to state a claim upon which relief can be granted, which is the cause of action. And then that is merged with preponderance of evidence, which proves it, which is now listed as a form of example here. And now they went into another realm where they start using words like allegations or alleges. And now they're giving you a full spectrum of what people should do and what people do now. Oh, you don't tidy your suit's complaint. Oh, okay, that's old news. Let's move past that. This is all conjecture that they're giving to you about what people do. That's why whenever attorneys respond, they would always use the word allege, because that is true. Most people do just make allegations. A claim without preponderance of evidence remains an allegation. But nonetheless, and what do most people do? They just say, oh, you violated the law. You violated the law. They allege that the tortfeasor has violated the law because they have not qualified for the element standards, the elements. They haven't brought in the other test or the other standards. And they have not introduced anything into evidence that a fact finder can see in its eyes to even begin to act as the stairway into equity in case all else doesn't work in that situation. In a negligent claim, the plaintiff would allege that the defendant had a duty and that they breached it, that their breach was the proximate cause of the plaintiff's injury, and that damages were sustained as a result. Remember, they're using the word allege now, but in truth, they just gave you everything you need right here. Just bringing the elements and the preponderance of evidence. But really over here, this is what people usually do. People just make allegations and just point fingers. You know, like the everyday man would do in everyday life to find an excuse, to feel significant about something, to find an excuse, to say someone is doing something wrong. Yeah, people just take that and they just put it on a piece of paper. And they expect someone to be held liable. They expect someone's check to be garnished. They expect someone's house to be liened or levied. They expect to win a case. They expect some type of settlement. They expect someone to go, oh yeah, you're right, we're wrong. Reality doesn't work that way. If no one has ever introduced the principles like these to you, then they are failing you. They are putting you on a height. Learn the elements. Learn the test, which is different but interrelated to element. Learn the standard, which is different but nonetheless interrelated. Those are 3 points of the triangle that you can merge the lines together to create something solid. Hey, I'm inviting you to join my Patreon if you haven't already. Over there, we speak about things that we don't speak of on YouTube. We speak about trust related matters and other subtle details regarding property and asset protection. We speak about financial related matters and a lot of things that people seek and can't quite put their hands on or get a better understanding of. We speak about child support, privacy, things of spiritual nature, subtle arts of suing and whatnot, discharge, and much more. Take a look at it. Take care. Best of luck.